SJC-13088, H1 Lincoln Inc., v. South Washington Street, LLC.
Attorney Cordy, welcome.
Thank you, Your Honor. Good morning to members of the court. My name is Robert Cordy, and I represent the defendant appellants in this case. With me is Annabelle Rodriguez. There are two parts to the case that I would like to address separately: the breach of contract claim, Part 1, and the delay claim, Part 2, both of which involve applications of 93A. First, for context purposes, let me tell you a little bit about Alfredo dos Anjos, who was at the vortex of this storm. Now in his late 70s, he came to this country with his family from Portugal at age 15. He had had 4 years of schooling there and began working in a grocery store at age 12. His family was very poor. When he arrived in the U.S. in 1959, he took 2 months of schooling to try to learn English and then went to work in factories in Rhode Island in order to help support his family as his father was unemployed. In 1965, not yet a citizen, he was drafted into the armed services and was sent to Vietnam, where he was badly wounded. When he returned home, he was awarded 6 medals for his service there. He got his factory job back, and several years later was introduced to the automobile industry by a friend. He became a salesman and climbed the ladder in the industry through hard work, good instincts about people, and honor in their dealings. He eventually owned 6 different dealerships, but in his late 60s, he moved towards retirement and began to dispose of them while retaining the properties. Property is very important to him, as you will see. It is the asset he is passionate about preserving for his children, his grandchildren, and future generations. Turning to Part 1, this court in the Canal Electric Company case, and in many other cases, has been clear and consistent in holding that liability limitation clauses allocating risks in contracts between sophisticated commercial parties are not contrary to public policy and should be honored, especially where the breach involved is purely a commercial one and does not affect the public interest. Indeed,
Counsel, what do we do with the exception in Canal that says we're not talking about willful conduct here? You know, in Canal, they're talking about purely commercial, garden variety breaches, but said, you know, when it comes to willful, we're not going to come forward on that one.
well, first of all, as I recall, Canal involves certified questions, and the court is usually very careful.
Right, but the court specifically said willfulness is a different story.
Well, maybe a different story. It
Yeah.
didn't really say what that different story was and how the distinction would be made, which is really what this case is, I think.
Well, they did say that the outcome, might have been different. Justice Abrams wasn't neutral in making that comment about the issue left open about willful dilatoriness or reputation.
Sure. I don't think that would be uncommon in answering a certified question, not wanting to go too far and really sticking to the facts of the case. Certainly after Canal, there's no question that statutory claims like 93A are considered consequential damages and would be included in a provision limiting such damages. So as you point out, and the question, most important question is, when will a liabilities limitation clause in a commercial contract not be enforced to exclude consequential damages, including 93A? And I have to say, it is apparent, it is a critically important question now that almost every breach of contract claim these days includes a 93A claim. So what distinguishes when a limitations clause can apply and when should it not apply is critically important. And I don't think this court has, first of all, specifically adopted the distinction, and secondly, given it full definition. What should the trial court really be looking for to make the judgment about whether this case, as they say in Standard Register and the exhibit course, or this exhibit source, this case sounds in tort. What does sound in tort mean?
Counsel, before you get to that, can I ask you about this particular limitation of liability clause?
Sure.
Because it's not a limitation of liability clause for all consequential damages. It's consequential damages caused by landlord's failure to perform its obligations under this lease. So unlike exhibit source and standard register, it's not a very expansive one. It's very tailored and tied to the landlord's specific breach of contract.
Well, it is that. It's certainly not as broad as some others have been crafted. I don't know what to say about that, other than...
Well, I guess the reason I ask is because unlike, even if we reject a tort versus contract analysis for 93A, this particular clause seems tailored just to the contract breaches and not 93A. It doesn't say, for example, anything related to the leasehold, limitation of liability for consequential damages, period. It's specific to the breach of contract, making it suggest that something other than contract damages, consequential damages for other than breach of contract is not waived.
It might be interpreted that way. It certainly hasn't been the case. But essentially, the damages in this case are contract damages. That's what this case is all about. This is contract damages. It's a breach of contract, a termination of the contract, which was found to be a breach, and we don't contest that at this point by any means. So it is a breach of contract case, and the damages...
But isn't it more than a breach of contract? Because I'm focused on the extra land, whatever that other parcel is.
Cash land.
Excuse me?
Cash land.
Cash land. Because that's not part of the contract. It's sort of a getting something for nothing provision. The idea that they sort of pressure the contract to get for $1 something they couldn't get for $900,000. Isn't that different? That takes us out of, doesn't that take us into willful or tort or some other world?
I don't think so, Your Honor. I'll explain why. Let me turn to the facts and circumstances leading up to that, because those are important. On July 25th, 2017, Belize submitted the new building demolition notice and site plan. Mr. Belize is the owner of the plaintiff. On July 25th, this new building demolition notice and site plan containing elevations, plans for 2 new buildings, and the joinder of the cash land into the site. That cash land had been conveyed to Mr. Belize on June 30th, just a few weeks before this was filed. Now, under Section 2A of the lease, the Dos Anjos and his team had 15 days to decide whether to just reject the plan or to terminate the lease. It's right there in Section 2A of the lease. 15 days from the submission to withhold consent or terminate the lease. The relationship went sideways, for sure, during this period of time. Mr. Dos Anjos had all kinds of concerns. Well, he's an elderly gentleman. He's trying to preserve his property. He had all kinds of concerns about what was going to happen here. And so a termination letter went out August 9th, drafted by his attorney, Attorney Mnuchin. After which Mr. Mnuchin received calls after calls after calls from Honda's lawyers. What can we do to settle this? What can we do to resolve this dispute and move forward? Because the cash land's acquisition by Belize and its proposed joinder with the Dos Anjos properties into a single business development plan was at the core of Dos Anjos' upsetness concerns, Mnuchin suggested that to Anjos, that perhaps those concerns might be resolved if the property was to be conveyed to him at the end of the lease. And Dos Anjos, at this point, responded that, well, perhaps a current acquisition of the land for $1, with no increase in the rent for the next 23 to 43 years of the lease, which would then include a much larger footprint, might make a difference. At this point, Dos Anjos may well have been fishing for a deal, as he testified, in response to these lawyers' pleas, can't we do anything to end this termination? In any event, Attorney Mnuchin forwarded the proposal and language to Mr. Belize, Honda, with the caveat that Dos Anjos had not yet decided whether he wanted to go forward at all. Honda accepted the proposal, but after a great deal of thought, Dos Anjos decided he did not trust or want to do business with Belize.
But the 93A fact-finding has a different flavor and tone and tint to it. In fact, there's the sense that Dos Anjos, at his deposition, he's just angry after all these years of trying to get this land, and $800,000 he's looking for it now, that H1 Lincoln or Majestic, they end up with the cash land, and it might separate him from another tenant, and he's just, as you get the flavor from the trial judge on the 93, he's just angry, and that there's a sense that this is vindictive. Is that?
Well, he certainly was angry about a number of things, one of which was that this cash land all of a sudden appeared on the site plan as owned by Mr. Belize, for sure, and that it was going to be consolidated in a single building development plan, for sure. It's interesting to note that the complaint filed in this case alleges that the termination was because Mr. Dos Anjos wanted to lease the property to a relative. Had nothing to do with extortion or anything of that sort. That's what they say. In any event, Dos Anjos, by sticking with the termination, walked away from more than $16 million in rent and this offer for the cash land. He walked away. He wanted out. He didn't want more. He wanted out. That may be a breach of the lease. Indeed, it was a breach of the lease. And there might be damages that flow from that. But that's the fact. And I think, I don't think that...
But counsel, that's not the fact, right? Because that's not what the trial judge found. The trial judge found different facts.
Which facts in particular? He found a lot of facts.
Well, the ones that it was about being upset about not getting this deal and trying to get this for nothing, and that he wasn't do this, and that's what was the motivation behind the actions of Dos Anjos.
Well, first of all, he terminated the lease, and in response to the lawyers saying, how can we fix this? This was proposed, it was accepted. He didn't want it.
But before that, though, there were other things that were brought up that the trial judge said, like the issue about the number of buildings, that your client threw that up as one of the reasons why that he was terminating, and that even though his lawyer had told him this was in the contract from the beginning, you initialed all the pages. All of these things went into the kind of the totality of the factual findings of the trial judge on the 93A issue. So I guess that's what I'm getting at, is that the judge found something different than what you're presenting.
I think the facts will speak for themselves. I understand what you're saying. Let me just say, because we're running very close and out of time, two things. First of all, if this court is to make a distinction saying tort, contract, I think it ought to focus on the core of the claims and the conduct that predominate. If the core of the claims and the conduct are tortious, then perhaps that distinction is appropriate. If not, I mean, in standard register, we're talking about fraud in the procurement of the contract. In the other case, the exhibit source case, we're also talking about essentially outside of the contract an effort to steal the property of the other party.
I want to go back to what Justice Wedland was talking about, though, as it relates to the limited liability contract, because Canal Electric Company is obviously, despite Justice Abrams' comments at the end, your best case. But in Canal Electric, the limited liability has reference of recovery, whether based on contract or negligence of any kind, or strict liability or tort or otherwise. So obviously, the question gets raised here with, at least with this limited liability, if we were to adopt Justice Abrams' standard, where do these facts fall into that standard that was left open? The dilatoriness, the willful dilatoriness or reputation. Take these facts, put aside the contract or tort dichotomy, and accept what Justice Abrams didn't reach but left open. That we might come out differently if it were a willful dilatoriness or reputation. What's the answer to that on these facts?
Well, surely this was a willful breach. It was a willful breach. It was a termination of the contract. He knew he was terminating the contract. Beyond that, is it a 93A? Isn't it a 93A? If it is a 93A, then the question is all of this primarily tort-based or contract-based? I can't say much about how one interprets the contract and the clause that Justice Wentland pointed out. But I would like to say one more thing on Part 2, just for a minute, if I might, and that is the delay in the permitting process. A couple of things. First of all, whether the Dos Anjos LLCs or the Dos Anjos Realty Trust were the title holders of those properties was a complete non-issue in the breach of contract case. First case, complete non-issue. Secondly, consistent with Dos Anjos' desire in life to preserve assets for his family, he had hired an estate planning lawyer, Edmund Slevin. The lawyer then set up the LLCs to own, operate, and develop the real estate assets that were in the real estate trusts. And they did just that. They were set up in 2008, and they owned, operated, and developed the properties as their own. No one understood that the realty trust had in fact remained in place and that what the LLCs owned were the beneficial interests. Even the judge essentially recognized on page 20 of his findings in the reopened 93A case that the true ownership only became fully apparent to Dos Anjos and his lawyers in June 2019, after their receipt of the May 31st letter from Mr. Egan's firm identifying this ownership disparity and the need for clarification, at which point Ms. Levin was contacted, a beneficiary schedule was provided to the Dos Anjos team, and the structural reason for the disparity became apparent. Obviously, subsequent efforts in June of 2019 and July to create an option that would preserve the property in the realty trust failed, and stipulated to add all the realty trusts as defendants on August 15th. There was no, as the court also found, Mr. Belize knew from 2016 to 2017 that indeed the realty trust owned this property. They were the title holders of the property. In fact, in November of 2017, just before they filed suit, he filled out a TIF application in which he averred that he was buying the properties from the realty trusts. He viewed this as a cleanup matter for the lawyers to take care of later on. It was never raised by the lawyers until May 31, 2019, and then they tried to take care of it. There's no 93A violation here. Thank you very much.
Thank you. Okay, Attorney Egan.
May it please the court, my name is Jack Egan, and with my partner, Michael McDonough, we represent the plaintiff, H1 Lincoln, which does business as Majestic Honda. The court knows from the record that there was an 8-day trial for jury, and then 4 days of 93A.
Can I interrupt you? Because I want you to address the last part of what your opposing counsel said about Part 2 and the delay. Wasn't your client on at least inquiry notice that there was a mess up somewhere along the line on who the lessor was and who actually owned the land? Why is that a 93A violation? I don't understand that conclusion.
Well, that's merely a piece of this course of conduct. But my client was on some type of due diligence notice that the record title, as opposed to the ownership, was in the LLCs. Clearly, we wouldn't have entered into a contract unless we were told that the LLCs were the owners, and it was a cleanup
Regardless
matter.
of what
So-
would have happened, how does it amount to a 93A violation?
Well, again, what I was
Of
trying to...
focusing on Part 2.
I understand. The 93A violation is just not the misrepresentation that caused us to be fraudulently induced into signing the contract. It also is...
I thought Part 2 was post bench trial. There was additional delay, I thought, is what the judge concluded, due to the failure of identifying the correct entity on the permit applications.
I misunderstood what you were referring to as Part 2.
Yeah, that's
and
why I thought I'd
apologize.
clarify, yeah.
You're
So-
talking about post the first 93A hearing
Yeah.
ruling, in
Yeah.
which the judge found the title was in the LLCs.
Right, and I'm jumping to the second 93A
Okay.
bench trial.
And what the judge found in the second 93A is that the defendants persisted in that incorrect position and refused until we inquired, I believe it was May 31st or something like that, with regard to a second title search, which indicated that this property was still in the realty trust.
Right, so we're all clear on the facts. How is that a 93A violation? I don't, you've
Well, it's a-
known, your client has known from the beginning, essentially, that this is the wrong entity. And then suddenly, post-trial, in May, they finally say, hey, this is the wrong entity. Why is, I don't understand why that's a 93A violation.
I'm sure I'm not doing a good job of explaining. That is not the 93A violation. There's no the 93A violation. There's multiple facts.
It's a huge centerpiece of it, February until May. The damages are for delay, just as Justice Windle was talking about. And this doesn't come up as an issue until June, and your client knows all about that it's the trust and not the LLC. I think it's inextricably intertwined with the delay damages.
Well, respectfully, by that point in time, we were 25 months into delay. The only additional delay that comes from June of 2019, I believe it is, goes to November 15th of 2019. So we're already into most of the delay damages, but more significantly, what happened during the course of that, we were reassured by false statements under oath, by false statements to the jury, that indeed the ownership was in the LLCs.
But that's a question of law, right? You just do a title search. It's not, I mean, and you guys did a title search and knew it wasn't. I mean, and you can just do another title search, can't you?
No, because of the difference between record title and ownership. And if you look at the affidavit that was filed by the defendants in this case, in opposition to our complaint and request for a real estate attachment, you'll see that Mr. Dos Anjos says, I have access to private records of the LLCs. And he swears in opposition that the LLCs own the property. That's pretty fair facts upon which we were reasonably found to rely. And remember, the trial court, none of the facts are challenged here, and the trial court found we reasonably relied on these assurances. Let me go further. After the affidavit was filed, in their answer, they indicate that the LLCs own the property. I believe that's a judicial admission.
Did you allege that they owned the properties in
Pardon?
the complaint?
We pled that they own the property. That's what
Okay.
we thought.
All right.
And they admitted ownership, and then they turned around.
Can I switch, unless my colleagues are still focused on this point? I find that as sort of a minor distraction, but I do see your point about that, and it fits within our case law, that there's been sort of an extortion of the contract to get the cash land. And that seems, I can't remember, there's a case that says you can't leverage the contract to sort of pressure something else.
That's Anthony's Pier 4.
Right, so
can't-
that one bothers, but are the damages that you're getting related to that? I mean, it's sort of a weird question, but I understand you've got $799,000 worth of damage, whatever, for that land, because you shouldn't have had to pay $1 for something that, was whatever, $800,000, $900,000. But how does that extortion figure into the delay damage? Because almost all of this money is consequential delay damages, right?
Yes, a bulk, the large bulk of it is.
So if the tort, do you need to connect the tort? Because I see a tort here, if we adopt the appeals court approach, which is that tort damages are different than contract damages. If we go that route,
The trial judge specifically found in the first 93A opinion that the misrepresentation with regard to ownership put us in,
he goes on and on about that, but it seems to me that the real misbehavior relates to cash land, not getting an LLC versus a,
well, I would respectfully disagree. Relying again on fact findings, the trial judge finds it wasn't just the cash land, it was the Honda exclusivity language, and it was the conversion of a $150,000 deposit. During that period of time,
well, those are separate bases for finding 93A violations, but we could decide, yes, the trial judge made too much of the LLC issue, but still find a 93A violation in your favor. What I'm worried about, though, is the pressuring to get that land, which seems to drive everything and blowing up the deal.
well, I would respectfully say not at all, because what Mr. Dos Anjos testified to is once we gave him the land, we agreed to the Honda exclusivity, we agreed to give him the land for $1.
Right.
He still said, and I quote, he was fishing for a deal.
I thought he was fishing for that deal, or is he fishing
Oh,
for?
no, we
Okay.
gave him that deal.
Okay, so he's fishing for another deal?
He was fishing for another deal, a
Or
better
is that
deal.
just, he's camouflaging what he really was, which is, once he got the land, he blew up the whole thing?
I'm not sure I understood the question.
I guess, to me, I find it difficult to find a willful breach of contract to be a 93A violation in and of itself, because you break contracts intentionally, as your brother just argued. But I don't think you're allowed to use the contract to extort something you're not entitled to. So I see that, but what I get lost in is the $5 million in damages, which are all related to delay damages, which you wouldn't be allowed to collect that, right? If there was just a breach of contract, you couldn't get delay damages, right? Because of the limit.
Yes, we could if there was no exclusionary language.
But there is. Let's
Okay, and
deal with this
well,
case.
the exclusionary language, if you look at the restatement, and if you look at the holdings of this court and also of the appeals court, is void as against public policy because it attempts to insulate someone for their intentional conduct.
No, I mean, the cost of breaching a contract is breach of contract damages, and if you have a limitation of liability clause that waives, as big boys often do, consequential damages, you're allowed to do that.
Oh,
That's not
certainly,
against public
You're allowed
policy.
to do that, and I didn't mean to suggest otherwise, but you're not allowed to do that if this is an attempt to shield you from intentional torts.
Well,
That's
I
the
mean,
restatement
what
which
do you
this
mean
court-
by intentional tort? If Mr. Dos Anjos had just said in July, I don't want to do this deal anymore, I terminate the contract,
We would have gotten,
you wouldn't be allowed
no,
consequential
but
damages.
there was an alternative finding for benefit of the bargaining damages, and we had to elect, and the alternative finding was $5.6 million. We took the lower amount
Well, because
because,
you wanted the auto road.
because we had made commitments to our manufacturer, we had made commitments to the town.
That's just a
we
business decision, I understand that, but you're
But-
saying you can intentionally breach a contract and also have a limitation of liability clause, and that's not against public policy.
Respectfully, I disagree, and I rely on Section 195 of the...
That can't be true, though, because then,
re-
that's the whole purpose of limitation of liability provisions.
I can read from Section 195 of the Restatement
read
of
away. I
Contracts,
mean, if
which
it's
this
a-
court has cited, that
If it's a
section.
tort, that's different, as Justice Wendland said, but you can have two big commercial entities can enter into a contract and limit liability even if they intentionally break the contract, can't they? Isn't that what?
Sure you can, but you
Isn't that- What
cannot,
about Canal Electric? Isn't that what that is?
no, Canal Electric makes a very specific carve-out with regard to conduct.
I'm gonna wait and ask you about the carve-out, but that's the big picture of Canal Electric is you gotta inform people, making a deal, like Justice Catherine Wedland had been saying, then go ahead, have a meeting of the minds.
Two things about Canal Electric. One, there's evidence in the record in Canal Electric that the court refers to, that the language, the exclusionary language, is common in the electric utility industry. No such evidence in our case. And the other thing in Canal Electric is the carve-out, which I'm happy to address, but would simply point out that the judge in this case found both willful deleteriousness and 6 separate breaches in his second 93A opinion. So Canal Electric really supports our position because it starts from the fundamental point that the Commonwealth, as a matter of public policy, is not going to provide.
So let's just say I, for one, disagree with you. Assuming that I disagree with you, what are the damages that flow from the unfair conduct that forms the basis of the 93A?
Those damages that were testified to and accepted by the court from our expert.
How does that different from the breach of contract damages? So there's
just-
damages that flow from the breach, right?
There are damages that flow from the breach.
Okay.
Right?
And so my question is, and I'm sorry to cut you off, but we are running out of time. What's the dollar figure tied to each one of the 6 to 8 misconducts that you're talking about, that the judge found?
Well-
There's a $150,000 deposit, right? That's one, because that was conversion. What else is there?
I guess what I'm struggling with is at least I hear in the question that I have to deliver a silver bullet. And what I'm saying is that this is a course of conduct over 4 years, so improper that the defendants in this case have to invoke their Fifth Amendment rights. I'm not trying to tarnish them, but I point out to the court that when they did that,
So if I go through the record, can I do this calculation, or is it just going to be this
I don't think you
gestalt
can.
of totality of the circumstances, and they were bad, and they did it for extortionate reasons that they didn't get at the end of the day, and I have to figure out what the number's right? Is that
I
what you're
don't
saying?
think you can.
Yeah. Okay.
Because.
Can we at least differentiate between one specific performance was elected, what the delay damages is, and be able to point to X, Y,
Yes, you
and
can,
Z
you
for
can
that?
surely do that. The trial judge finds they were like $172,000 a month based upon the expert. So, and he finds in his first 93A hearing that was 21 and a half months, and then in the second opinion, he extends that from January, I think, to the following November. So certainly, there's a unit price with regard to the delay damages. There's also a waiver issue here. At no time before the trial, the first trial, the jury trial, was there a request for instruction on the Canal Electric concept, the exclusionary language concept? Was it in their motion for a directed verdict? Was it raised at the charge conference? Was it raised subsequent to the judge's instructions? There was no objection to the absence of an instruction on the exclusionary language. I also want to, I understand I'm over, want to simply underscore the exclusionary language, even if it were to be allowed, in our view, does not affect 93A and is in conflict with the same paragraph in which previously it says that we're entitled to all damages at law and attorney's fees. So in conclusion,
Can I ask you before you conclude, was the issue of the limitation of liability at play at the 93A bench trial?
It was raised 41 days after the evidence closed. I believe I've got it. It's in our brief. 41 days after the evidence closed in a motion, not sure if it was for directed verdict or subsequent.
Okay.
But it had not been raised previously. And of course, it's germane to damages in the jury trial issue.
Well, it's germane to contract damages, and I thought you were specifically awarded 93A damages.
Not from the jury.
No, I know.
So
You were awarded 93A damages by the judge in the bench trial during which the issue of limitation of liability was raised, 41 days after the
after
close
it
of
had been
evidence.
waived in the jury trial, when the jury awarded us damages based upon the absence of the defendants raising the exclusionary language. So in effect, what they're asking is, can they resurrect it after a jury trial in their 93A case? And our position is they should not be able to do that. For those reasons, we respectfully request that the trial judges' judgments, the trial court's judgments be affirmed.
Thank you.